hope that's better. There is an argument that access to justice is a fundamental human right. Every person should have the right to have his or her dispute vindicated before an independent judge, hearing the evidence and coming to a binding and determinative conclusion. That fundamental human right is absolute. But the problem with that absolute fundamental right is actually enforcing it. It's no use having a fundamental right that is interrupted by going to courts where there's a backlog of millions of cases, or starting a case that is going to be inherited by your children and your grandchildren. We, in England, bequeath to you a legal system that has moved on in England, and we hope that it moves on in this country. I'd like briefly to talk about the English experience. In England, until 1999, we had a legal system that is very similar to the one that you have here. The same story, cases with backlogs running to millions, no proper access to justice, such that it required a fundamental rewrite of our civil procedure code. We imposed an obligation on parties not to start their court cases immediately, but to engage in pre-action protocols, which required parties to set out their case fully and to identify issues, exchange evidence, and fundamentally to engage in alternative dispute resolution before taking the matter to a court. That has had a fundamental impact on the backlog in cases. And of course, ADR, which was unknown to English barristers until the early 2000s, has become prominent in resolving our disputes. And what I'd like to do now is to discuss the Pakistani experience by starting with the court's backlog and pendency of cases in Pakistan. Perhaps I can invite Justice Shahid Jalil Khan to tell us about the issues that we have here.